pleas were entered at the earliest possible opportunity. I turn to sentence. For the grave offence of murder, there is only one sentence prescribed by law, and that is imprisonment for life. That is the sentence I shall impose upon each of you in due course. However, I am required to determine whether a minimum period of imprisonment should be set for each of you before you are eligible to be considered for release on parole, or whether I should impose a whole life order. As you were both over 21 years of age when the offence was committed, by Section 321, subsection 3 of the Sentencing Act 2020, I must pass a whole life order if I am of the opinion that because of the seriousness of the offence, I should not make a minimum term order. That is a question which must be resolved separately in the case of each of you. Your circumstances are different, and it does not follow that if a whole life order is appropriate for one of you, it is appropriate for the other. If a minimum term is appropriate, I must determine what the period of it should be. The facts underlying the offence of perverting the course of public justice are aggravating features of the murder. I treat them in that way. The sentences for perverting the course of public justice will be concurrent to the sentences imposed for the murder. In considering the seriousness of the offence and the appropriate starting point, I must consider where in the case of each of you this case falls within Schedule 21 of the Sentencing Act. Turning first to you, Sansom. You are now 45 years of age. You have been previously convicted of murder. In your case, this case therefore falls within paragraph 2 of Schedule 21, and the starting point for the murder must be a whole life order. A whole life order does not necessarily follow. It should only be imposed when the offending is so exceptionally high that just punishment requires an offender to be kept in prison for the rest of his life. On the facts of this case, considered as a whole, I am in no doubt that this is such a case. I have come to that conclusion for the following reasons. First, there are a substantial number of aggravating factors. First, there was a significant degree of planning and premeditation to the murder. I am satisfied from the messages sent between you that the murder involves sexual and sadistic conduct, which must have caused mental or physical suffering to Sarah. Together with Watts, you dismembered and concealed her body afterwards, and you destroyed and disposed of relevant evidence. Second, there is absolutely no mitigation. I recognise that you pleaded guilty to both counts on the indictment on the 26th of September of last year. Those pleas were indicated to the prosecution on the 19th of June. By so doing, you have saved Sarah's family the additional anguish of having to sit through a trial. The Sentencing Council's overarching guideline on reduction in sentence for a guilty plea states in terms that where a court determines that there should be a whole life order, there will be no reduction for a guilty plea. It is something, however, that I have considered in determining whether the seriousness of the case is exceptionally high and requires a whole life order. I have determined that notwithstanding your guilty plea, it does. As you realistically concede, the plea cannot of itself reduce the seriousness of this case to the extent I can impose a minimum term, even of substantial length. I place the offence of perverting the course of public justice into Category 1A of the relevant sentencing guideline. It is of high culpability as the underlying offence is the most serious. It was also conduct over a sustained period of time, as well as being sophisticated and planned. It falls within Category 1 harm because it had a serious impact on the administration of justice. The extensive nature of the perverting, including the separate deposition of Sarah's torso, meant that the precise circumstances and sequence of the murder had to be based on circumstantial evidence. This has a starting point of 4 and a range of 2 to 7 years imprisonment. Affording a third credit for the guilty plea, the sentence will be 1 of 5 years imprisonment on that count, which will of course run concurrently with the life sentence imposed for the murder offence. Gemma Watts, I turn to you. You are now 49 years of age. You have a very old conviction for theft in 1998, but I treat you as a woman of previous good character. Good character, however, carries very little weight in a case of this seriousness. But that does distinguish you from your co-accused. This remains an extremely serious case for all the reasons I have identified. But in my view, there are no features in your case which replace the offence within paragraph 2 of Schedule 21. A whole life order is therefore not appropriate. That means that I am required to determine the minimum period you should serve in prison before you are eligible to be considered for release on parole. It is most important that you and everyone concerned with this case should understand what in fact this means. The minimum term is not a fixed term, after which you will automatically be released, but the minimum time that you will spend in custody before your case can be considered by the parole board. And it will be for the parole board to say at that time whether or not you will be released. If they say you should not, you will remain in custody. If and when you are ever released, you will be subject to licence, and this will be the case for the rest of your life. If for any reason your licence were to be revoked, you would be recalled to prison to serve your life sentence in custody. The offence falls in my judgment within paragraph 3 of Schedule 21. The seriousness of the case is particularly high as it is a murder involving sadistic conduct. The starting point for the minimum term is therefore one of 30 years imprisonment. Your counsel has submitted that there is no evidence in this case that your murder of Sarah Mayhew involved sexual in addition to sadistic conduct. I reject that proposition. It is plain from your messaging prior to the murder that the reason for Sarah to be invited to Sansom's flat was to involve her in sexual activity during which she would be killed. You rightly accept that this is a murder involving sadistic conduct, as a level of pleasure was your motivation. As your messages make clear, that pleasure was sexual in nature. There is a clear and proper inference, in my view, that this murder involved sexual and sadistic conduct. In your case, there are the same significant aggravating factors which I have already set out in relation to Sansom. There was clearly a significant degree of planning and premeditation. Together with Sansom, you dismembered and concealed Sarah's body afterwards, and you destroyed and disposed of relevant evidence. It is also right to observe that mental or physical suffering was inflicted on Sarah before her death. I take care not to double count this factor with your sadistic conduct, although they are not entirely the same. The sadistic aspect of your conduct goes to your motivation. Sarah's suffering is, of course, focused on the consequence of your offending to her. I take into account all that has been said on your behalf. As I have said, you were of previous good character. I accept you had a difficult childhood and you have had a difficult life, but have clearly suffered mental health difficulties for some time. Whilst you have been involved in sadomasochistic behaviour for many years, you have not been the one previously to mete out violence. I accept that this murder would not have happened had it not been for your association and relationship with Samson. This does not assist you in my view. It is frequently the case that people behave together in ways they may not if alone. This is such a case. You properly do not blame Sansom for your conduct. The messages make clear that this murder was not suggested by him and your will overborne. You were in it together. In truth, this affords you, in my view, little in the way of mitigation for this serious offence. I have read Dr. Salim's psychiatric report and the chronology of your medical notes with care. As I have said, I accept that you had a difficult childhood and in many respects have had a difficult life. You have been diagnosed with personality disorder with negative affectivity, borderline pattern, previously known as unstable or borderline personality disorder. I accept that amongst other symptoms, this has caused a pervasive pattern of instability of interpersonal relationships, resulting in frantic efforts to avoid real or imagined abandonment, and a tendency to act rashly in states of high negative effect, leading to potentially self-damaging behaviours. It may be that you were in consequence concerned about losing your relationship with Sansom, whom you described to the psychiatrist as perfect for you. In your own words, you were obsessed with him, and he enjoyed the same type of sadomasochistic sex. It cannot be said that you did not play a full and active part in this well-planned murder. Your strongest mitigation is your guilty plea, which I am told you entered before much of the evidence had been served in this case. I have already said that I consider that came at the earliest opportunity. Your legal representatives were entirely right to obtain a psychiatric report before they could properly advise you. As with Sansom, those guilty pleas have saved Sarah's family the additional anguish of having to sit through a trial. As the overarching guideline on reduction in sentence for a guilty plea states, careful consideration must be given to the extent of any reduction to a minimum term for an offence of murder to ensure that the minimum term properly reflects the seriousness of the offence. Any reduction will not exceed 1/6 or 5 years, whichever is the less. I consider that you should be given full credit for your guilty plea. For the same reasons as in the case of Sansom, I place the offence of perverting the course of justice into Category 1A of the relevant sentencing guideline. I see no reason to distinguish between you in terms of the length of that sentence. I have taken the facts of the perverting offence into account as aggravating the offence of murder. The sentence will be concurrent to the minimum term. In your case, taking all the circumstances of this case into account, and prior to any discount for plea, I conclude that the minimum term you would have served before you were eligible for parole would have been one of 35 years. I reduced that term by 5 years to one of 30 years by reason of your guilty plea. From that, I must deduct the time you have spent on remand, which I am told is 275 days. The minimum term will therefore be one of 29 years and 90 days. Stand up, both of you. Stephen Sansom, for the murder of Sarah Mayhew, I sentence you to life imprisonment. I set no minimum term in your case. That means that you will spend the rest of your life in prison. For perverting the course of public justice, the sentence is 5 years imprisonment concurrent. Gemma Watts, for the murder of Sarah Mayhew, the sentence is one of life imprisonment. You will serve a minimum term of 29 years and 90 days. Thereafter, it will be for the parole board to decide when, if ever, you should be released. If you are ever released, you will remain on licence for the rest of your life. For perverting the course of public justice, the sentence is 5 years imprisonment concurrent. You may go down.